Division 2 of the Court of Appeals of the State of Washington is now in session. Chief Judge Ann Cruiser presiding, also sitting Judge Bradley Maxa and Judge Bernard Veljacek.
Thank you. Be seated, please. All right, the first case this morning we have three cases on the calendar, and I'll mention that we're going to be taking a break after the second case to reconstitute the panel, but we'll handle the first two cases without a break. The first is Synnex Corporation Appellant versus State of Washington Department of Revenue, Respondent, and I understand that you've reserved 5 minutes for rebuttal, Mr. Edwards?
That is correct, Your Honor.
All right. So case number I should note is 595613. So go ahead and begin when you're ready.
May it please the court, Scott Edwards representing the appellant, Synnex Corporation. At council table with me today is my partner, Callie Castillo. There are specific provisions of the Department of Revenue's Rule 193 that conflict with the controlling statute, RCW 8232-730, with respect to the sourcing of drop-shipped wholesale sales, and therefore those provisions are invalid under the Administrative Procedures Act. RCW 8232-730 sets out a hierarchy for sourcing sales of goods. First, when the purchaser receives the goods at a business location of the seller, then the sale is sourced to that business location of the seller under subsection 1A of the statute. Second, when the purchaser does not receive the goods at a business location of the seller, the sale is sourced to location where the purchaser or its donee, designated as such by the purchaser, receives the goods, and that's sourcing under subsection 1B of the statute. Third, when the first two steps do not apply, the sale is sourced to the purchaser's address as shown in the seller's business records under subsection 1C. In a drop-shipped wholesale sale, the first two steps do not apply because the goods are not received at a business location of the seller or by the purchaser or its donee.
Well, isn't the question is who is the purchaser? Is it the ultimate customer or is it the retail seller?
With respect to
question?
No, when you say the purchaser, there are two different sales, and with respect to the wholesale seller's sale, there is only one. The purchaser is the one who purchases from the wholesale customer. Thus, there is no suggestion that the purchaser's customer is the purchaser in the context of the statute, but the department rule is simply saying that the shipping destination where the purchaser's customer receives the goods is where the sale should be sourced. There's not an assertion that the purchaser's customer is the purchaser for the purpose of the wholesale sale. The purchaser's customer is a purchaser for the second sale, that is the sale from the wholesale purchaser to its customer.
But don't we have to look at this as a whole, though? And the court in the Avnet pointed out, but for the first sale, the second sale would never have occurred. So why don't we look at it as a whole?
Well, Avnet involved the time period 2003 to 2005. It predated both RCW 8232-730 and the amendments that are at issue here. So Avnet doesn't control the issue in this case, which is where does RCW 8232-730 cause the sale to be sourced for Washington tax purposes?
Counsel, can I jump in if I may? Nevertheless, isn't Avnet's discussion or conceptualization of a dropship transaction helpful? It's at 62, 63 of the case, forever, and I guess we all have it, 187 wins second, 44. But isn't that nevertheless helpful to guide us in terms of where this transaction is initiated? And
well, the description of the fact pattern may be helpful, but analysis involved former version of Rule 193 that is materially different here in several respects. First of all, under the prior rule, which did not have a statutory basis, and there was no argument or any question about the validity of the rule was not in front of the court, but the standard there was where receipt by either the purchaser or the purchaser's agent occurred, and then agent was a defined term. Both the standard of sourcing to where receipt by the purchaser's agent, that part was removed from the rule, and the definition of agent was removed from the rule. So, the Avnet was dealing with a different law that is, and so I don't think its analysis of the law as it existed then has any bearing on the issue before the court here, which it now deals with a statute that was enacted after the period at issue, an amendment to a rule, that the rule was amended for the purpose of incorporating the statutory change. So I don't think that Avnet helps one way or the other with respect to the analysis of the issue before the court.
Thank you, Cal.
So you say the term purchaser in the statute refers to the wholesale purchaser. DOR says purchaser refers to the ultimate consumer. Doesn't that make the term purchaser ambiguous?
That's not actually what the rule isn't asserting that the answer or that the conclusion of shipping destination is because the purchaser's customer is deemed to be the purchaser. Their argument is that under 1B, you source to the known destination if you know what the destination is. That's not what 1B says. 1B says if there's not receipt at the place of business of the seller, then you look to the receipt by either the purchaser or the purchaser's donee designated as such by the purchaser. That statutory language that recognizes that the difference between the purchaser, the person who is buying from the seller, and somebody else. The purchaser's customer is not the wholesaler's purchaser. They're not purchasing from the wholesaler. The rule doesn't claim that they are purchasing from the wholesaler. The department has basically made three arguments. One that I've just talked to under 1B, which is simply contrary to the statute, because you have to look at the purchaser or the purchaser's donee designated as such. That's where delivery instructions are relevant. It's not the fact that there are delivery instructions and you simply know what the destination is.
Well, it refers to receipt by the purchaser, and the only person that actually receives the good is the end consumer.
Yeah, but under the statute, you've got a hierarchy. 1, receipt by the purchaser at seller location. 2, receipt by the purchaser at a different location. 3, A and B do not apply, recognizing the purchaser does not always receive the goods. And in a wholesale drop situation, the purchaser does not receive the goods, which is why 1C is what applies.
Counsel, can I just interpose a question, just so I understand your argument better? Under 1B, who is the purchaser and who's the seller?
With respect to a wholesale sale, the purchaser is the person purchasing from the wholesale seller.
Then who's this? Okay, so the seller in this is the person up here, purchasers in the middle, and then the final consumers down here.
There are two different sales. There is a wholesale sale from the wholesaler to the seller/reseller. The seller/reseller is the purchaser in that sale.
Right.
Then there is a second sale. The B&O tax is an activities tax imposed on business activities. The wholesale seller is subject to tax on its business activity of selling to its purchaser.
I understand that. So my question was simply, in 1B, you're saying that they mean the same thing, essentially.
I'm saying, well, 1B is looking at a specific sale. When you're trying to source a sale, You look to where the purchaser in that sale is located, not where the purchaser in some different sale that you're not trying to source. And so there's no receipt by the wholesale purchaser. There is receipt by the reseller's purchaser, but the reseller's, the B&O tax obligation is a separate tax obligation because it's a separate sales transaction. So in short, the statute, the provision in the rule simply asserting that the sale is sourced to the shipping destination is contrary to the plain language of the statute. It also, there's absolutely nothing in the rulemaking file reflecting why the department came to that, took that position, or how that position potentially relates to the statute that the rule is interpreting. I'll reserve the remainder of my time.
Thank you, Counsel. Melissa? Go ahead, when you're ready.
Good morning, Your Honors. May it please the Court. I'm Callie Barrett, counsel for the Respondent, Department of Revenue. Rule 193 is a valid interpretation of the statute with respect to drop shipment transactions. It sources sales of drop ship goods where the purchaser receives them, consistent with our Supreme Court's reasoning in Avnet. This court should affirm the trial court's order dismissing Synnex's rule challenge for 3 reasons. First, the rule is supported by the plain language of the sourcing statute and the legislative intent that the B&O tax apply broadly to all business activities occurring in Washington. Second, Avnet already held that the purchaser, for purposes of sourcing drop shipments, is the ultimate recipient or customer. Third, the rule is not arbitrary and capricious. I'll focus my argument on the first 2 points unless the court has questions about the third. To begin, the APA standard for invalidating a rule is high. Agency rules are presumed valid. Any rule that is reasonably consistent with the underlying statute must be upheld. Here, the underlying statute, RCW 8232-730, requires sales to be sourced under a hierarchy, as my friend here discussed. When goods are not received by the purchaser at the business location of the seller, which is the case here in a drop shipment, the second sourcing step requires the sales to be sourced to the location where receipt by the purchaser occurs, including the location indicated by instructions for delivery to the purchaser known to the seller. Consistent with this plain language, Rule 193 explains that the place of receipt by the purchaser in a drop shipment is where the goods are delivered.
So again, the question is, what does purchaser mean? And Mr. Edwards says purchaser is the wholesale purchaser. Sounds like you're saying that purchaser is the ultimate consumer. Is that correct?
That is correct. The statute does not focus narrowly on the term purchaser, but it focuses on the location of receipt by the purchaser. Interpreting purchaser as narrowly as Synnex suggests is inconsistent with the legislative intent to source the place that the goods are delivered. This is indicated by the language that in a retail sale, the purchaser can designate a donee, a gift recipient, to receive the goods, and the seller is to source the sale to that location, not to the purchaser's location, but to the location where the goods are ultimately delivered. The statutory definition of receipt also supports this interpretation. Receipt means taking possession of the goods. The only place that any purchaser takes possession of a drop ship goods is upon delivery. That is by design. That is the whole purpose of this transaction, where there are 2 sales, 3 parties, but only 1 receipt of 1 set of goods.
Although if we focus only on the wholesale sale, because that's what's being taxed, right? It's the wholesale sale between Synnex and the retail seller, right? So if we focus only on that, the customer is not the purchaser in that sale, right?
Right, but if you look at the drop shipment transaction as a whole, the wholesale sale would not occur if not for the customer placing the order with the seller and having the seller direct the delivery to the customer, to the location of receipt. The wholesale sale is not consummated until the wholesaler delivers the goods. So looking at the purchaser as narrowly as the wholesale purchaser and ignoring the customer is not really the reality of a drop shipment situation, where the customer is a crucial part of this 3-party 2-sale transaction. And interpreting purchaser as narrowly as Synnex suggests has already been rejected by both this court and the Washington Supreme Court, which interpreted the very same phrase, receipt by the purchaser, with respect to a drop shipment transaction, and held that B&O taxes properly apply to the ultimate recipient because the only transfer of possession of property to any buyer occurred in Washington when that customer was in Washington. The Supreme Court also did a common sense breakdown of this exact transaction, noting that the common sense breakdown of the dropship sale demonstrates that the purchaser is the ultimate recipient in Washington. The out-of-state company, the seller, is presumably placing the order only because it first received an order from the Washington customer. The payment for the product originates in Washington, and the product is delivered in Washington. The result is that the ultimate recipient in Washington is, for all intents and purposes, the purchaser of the goods.
So Avnet does deal with an earlier version of Rule 193, and it didn't have anything to do with the statute. So why can we rely on Avnet?
Your Honor, because the language in Avnet, the former Rule 193, first, it was the same phrase that the statute now uses. It required sales to be sourced at the location of receipt by the purchaser. It is immaterial that the statute was not enacted yet because the courts did an analysis of this exact factual scenario of this complicated transaction and decided that the common sense purchaser under the phrase receipt by the purchaser in the former rule means exactly what the current rule now states in the drop shipment provision. Now, Avnet is not controlling because that case did involve a challenge to the imposition of B&O taxes under the former rule. It did not challenge the rule's validity under the statute, which was not in effect at the time. However, there's no reason for this court to ignore the reasoning in Avnet that addressed this very same situation.
Can I take a step back and talk about the two transactions?
Of course.
So the first sale is between the customer and the retail seller, right? If the retail seller has a nexus with Washington, that's taxable, right? The retail seller has to pay B&O taxes on that sale, correct?
Correct, retailing B&O taxes on that
So,
sale.
and then you're taxing the wholesale sale. So are you basically taxing the same sale twice?
Yes, but the B&O tax scheme is based on the tax activity, the business activity. So this is common in the B&O tax scheme that a particular business activity, say if it's retailing, then it's subject to retailing. If it's wholesaling, it's subject to wholesaling. You're taxing there is one transaction, but two types of business activities. So it's wholly consistent with the B&O tax scheme to apply Washington taxes when both of those business activities and sales are consummated in Washington. But this goes both ways. The wholesaling B&O tax would not apply when any customer in any other state places an order and the wholesaler ships the goods to that state. Again, this is just a way of allocating business income fairly amongst the states, consistent with a statutory scheme, which was adopted in order to have a streamlined process and understanding of the methodology for sourcing of sales across all states. So again, it's not a double taxation situation. It's simply there are two business activities, and when both of those activities are largely occurring or fully occurring in Washington, Washington imposes tax based on those activities.
So what do we do if we think your argument's reasonable, but we think Mr. Edwards' argument is reasonable as well? What do we do then?
Well, in that case, then the rule must be upheld because if there's room for two interpretations or two opinions on the statute, and the agency rule is reasonably consistent with the underlying statute, the rule must be upheld. It is only if this court finds that the rule exceeds the statutory authority set forth in the sourcing statute that the rule should be invalidated. Where there's room for two opinions, the department's interpretation must stand. I will note that both the Avnet majority and the concurrence specifically wrote separately to stress that for B&O tax purposes, the purchaser in these transactions is the entity that ultimately takes possession of the goods, regardless of the fact that there was a broker in the middle, the seller, who placed the order on behalf of the ultimate purchaser. Again, it would be inconsistent with both this court's reasoning and the Supreme Court's reasoning to find that in these transactions, receipt by the purchaser means something entirely different than what Avnet already interpreted. So to the extent that I'll talk a little bit about the arbitrary and capricious argument, and I just would like to note that that argument cannot stand unless the court finds that the rule is inconsistent with the statutory framework. which is not the case here. There's no other evidence in this record that the department's rule is arbitrary and capricious. The department acted reasonably in enacting the rule. It explained its reasons for incorporating the drop shipment provisions, one of which was that the former rule from 1992 did not address drop shipments. It addressed drop shipments in only one example, and in that example, the department did not provide guidance for wholesalers on their B&O tax liability. This was played out in Avnet, where the wholesaler did not understand its B&O tax liability and thought that under the former rule and the former example, which was misleading, it should not owe B&O taxes. The factual circumstances leading to these amendments were entirely consistent with the need for some explanation. It was not sort of a 180 that the department did. It was a recognition that there needed to be further guidance, and the rule was also amended to include the statutory definitions to exclude possession by a shipping company and other such changes. The rule did not materially change, as Mr. Edwards states, from removing the definition of agent or changing the definition of purchaser. It simply rearranged the terms and the definitions in the rule and incorporated the definition of possession by a shipping company as excluded from receipt. If the court has no further questions, I will cede the rest of my time.
Thank you, counsel. Go ahead when you're ready.
I think I'd like to address 3 points. The proper interpretation of subsection 1B of the statute of purchaser and the amendments to Rule 193, distinguishing it from Avnet. First of all, the hierarchy applies to all sales and to each sale separately. And when there is a drop ship scenario, there are 2 separate sales involving 2 separate sellers and 2 separate purchasers. And each of those sales is sourced under the statute with respect to that sale alone and not looking to some other transaction. And so the word purchaser in context has to mean the purchaser in the sale that is being sourced. And the shipping recipient, the purchaser's customer, is simply not the wholesale seller's purchaser, and therefore is not the purchaser for purposes of trying to source the wholesale sale. That gets it. And so when you look at 1B, you need receipt by either the purchaser or the purchaser's donee designated as such by the purchaser. That statute in context recognizes the singular identity of the purchaser, and it doesn't allow context to say, even though you're not the one buying from this seller, even though you're the one buying from the seller, we're going to treat somebody else as being the purchaser from this particular seller. So the rule directly conflicts with the plain language of the statute.
Counsel, if I may interrupt, what do you make of this no sale issue, that would result in no sale?
No, it's not that it's no sale, it's where the sale is sourced to, and the sale is sourced to the purchaser's address. Mm-hmm. If the purchaser's address is in Washington, it's going to be a Washington sale. But if the purchaser's address is somewhere else, it's going to be a sale in that jurisdiction. For B&O tax purposes, only sales that are Washington sales are taxed by Washington. That doesn't mean that the sale isn't a sale. It just means that it's sourced somewhere else. And so it's those sales that are sourced to Washington under the statute that are subject to Washington tax. Sales that are sourced elsewhere would be taxed by the state in which the sale occurs.
Thank you. And going back a little bit, I'm still struggling. I know, of course, you disagree with me. I don't know where I'm going to land on this, but the Avnet language in terms of those what are described by you as two separate transactions, that yet they wouldn't exist were it not for that end purchaser, retail customer, retail buyer, whatever you want to call that person. Under the Avnet's description of that transaction, these activities, business activities between the wholesale seller and the wholesale buyer would not exist but for this initiating transaction.
So, well, but Washington's B&O tax is imposed on each person for that person's own activities. And you know, to get a little bit far-fetched, there's two different types of activities. Some are apportioned formulaically because they're recognized as occurring partly in multiple places. Others are sourced entirely to one location that's either going to be inside or outside of Washington. Sales of goods follow that scenario. So because one person wants to buy something, you know, there's a sale between the reseller and that end consumer. In order to fulfill that sale, that person makes its own separate purchase from a wholesale seller. That's a second sale. The statute looks for B&O tax purposes on that sale, at that seller, and how that sale is sourced. Why its purchaser decided to make the purchase is not relevant to the sourcing under the statute. We've got a hierarchy, and in this fact pattern, the hierarchy addresses it. It's a fact pattern where the purchaser does not receive the goods, and therefore the sale is sourced by statute to the purchaser's address. And for those reasons, we ask the court to reverse the trial court and strike the invalid portions of Rule 193.
Thank you.
Thank you, counsel.